Thank you very much for joining us for the second day of the Minerva Conference on the Gaza War and International Law, Norms, and Institutions. Uh, we'll start tomorrow with a session on weapons laws issues, and we have three excellent speakers, and I've read them, and these are excellent papers. So two of our speakers are via Zoom. We'll start with Dr. Natalie Davidson, and then we'll go to our Zoom presentations. Natalie. Dr. Natalie Davidson is a senior lecturer and vice dean at the Buchman Faculty of Law at the Tel Aviv University. She researches and teaches international human rights law, constitutional law, and the international regulation of the arms trade from a socio-legal perspective.
So thank you very much. Thank you to the conference organizers. So the starting point of this project, which is really in its early stages, and the conference really gave me an opportunity to put my thoughts together here. So the starting point is the basic insights from scholarship in law and society, and also from critical legal scholarship, that law often plays two contradictory roles in relation to violence. It is both constraining but also legitimating. And in a nutshell, the tentative argument here is that until recently, the international law of arms transfers has been primarily legitimating of the global arms trade, but that since October 2023, its constraining role has been strengthened, with the law being interpreted by a number of actors as imposing more resolute constraints to protect human rights and humanitarianism. Or at the very least, so this is a tentative argument, so I'm still exploring and researching this. At the very least, I think we can say that in the area of international norms related to the arms trade, we're at a critical point where the balance, the tension between constraint and legitimation of the global arms trade is being fought over. Yes, it's working. So the international law of arms transfers, what is this? Well, it's not a recognized area of international law, and that's part of the ambivalence of international law towards the trade. It's a patchwork of norms from a number of areas, including some that I didn't even list here, like the laws on the use of force and sanctions regimes, but norms primarily from international human rights law, IHL, international criminal law, disarmament treaties, and non-binding international regimes. And I would like to argue that in general, this patchwork of norms has been deeply ambivalent about human harms. So international law in each or most of these fields recognizes the problem of arms causing profound harms to human rights, and international law has a language apt to name and address this problem. It has a language of complicity, of assistance, of assistance in situations of risk or knowledge. Yet it is very difficult to enforce these norms, or to even determine that they're applicable to the arms transfer, due to normative ambiguity. The norms are either too abstract, too vague, or too narrow, leaving states much discretion. So, yes. So I could give many examples, and as I said, it's a patchwork, so there are many different norms that are relevant, but I'm just going to focus on the Arms Trade Treaty in the interest of time, and because this is civil society's greatest achievement to date. I think we can say in the area of the international constraint of the arms trade. It entered into force in 2014 with 116 member states to date, and it focuses on the licit trade in conventional weapons. The treaty imposes obligations promoting standardization in export controls and increased transparency about export control decisions and practices. And most relevantly for us, it constrains transfers that are particularly problematic from a human rights perspective. And it was conceived in part as a human rights instrument, and it explicitly sets out in its Article 1 to, and I quote, establish the highest possible common international standards for regulating or improving the regulation of the international trade in conventional arms, end of quote, for the purpose, among others, of reducing human suffering. But even this treaty reflects the ambivalence I was talking about. So the ATT clearly recognizes the potential harms of the arms trade, of arms transfers to human rights and humanitarian principles, but it sets an extremely high standard in order to clearly ban transfers. That is, to have a bright line rule. So here in Article 6, prohibition on authorizing a transfer of conventional arms. But this is limited to situations where the exporting state has knowledge, okay, it's a knowledge standard at the time of authorizations that the arms or items would be used in the commission of, and then only the list of, the worst crimes possible. In other situations that are not covered by this very narrow Article 7 mandates assessing the potential for serious violations of IHL or IHRL. But this human rights risk assessment, which follows the standard model of of arms export risk assessment in liberal democracies, is done on a case-by-case basis. Okay, so it's per transaction, per sale, and it leaves great discretion to the state to weigh human rights against other considerations. So here you have in particular subparagraph 3 of Article 7 at the bottom, which states that the exporting state will not authorize the export if it determines that there is an overriding risk of any of the negative consequences, including to serious violations of IHL or IHRL. The term overriding risk was a big point of contention during the negotiation of the treaty. It's not clear at all what this means, overriding in relation to what, to mitigation measures that are possible or to other interests. And there is quite a bit of scholarship now developing critically that criticizes this article and the dominant model in Western democracies that's based on risk assessment for being extremely permissive and legitimating in relation to the bulk of arms transfers and only constraining the most extreme cases. So this is just one example, but I could go through other norms that are relevant here and show a similar ambivalence. But I think this is important because this is supposed to be the highest standard and the big achievement. So this tension we could see as simply reflecting, well-known tensions in international law between human rights and peace on the one hand and sovereignty on the other. But I also would like to emphasize that this tension reflects the particular structure of the global arms trade. So I can't go into all the aspects, all the features of the global arms trade. I'd just like to highlight one aspect. I don't know if you can see here. This is the list of the 20 top exporters for the years 2019-2023 from the Swedish organization SIPRI, which is the place to get information about the arms trade. As you can see from this list, the top exporters in the world are overwhelmingly Western liberal democracies. There's also Russia and China here, but overwhelmingly this trade goes in a north-south direction. And so why is this relevant to the ambivalence I'm discussing between human rights on the one hand and preserving immense state discretion on the other to export is that it is precisely and paradoxically those states with both normative commitments to human rights, including in their foreign policy, and with the standing to be effective norm entrepreneurs on this topic, who also have, for a number of political, economic, and financial reasons, the highest motivation to export arms. So I won't go into all the motivations of those states. There's, for the United States and other states, there's one objective is influence, diplomacy, but there are some very clear technological and financial constraints. In brief, in order to make the very high investments required of development of high technology weapons, you need a large market to sell to, and most of the states, excluding the United States, don't have a large enough army or domestic market to sell their products and constant updates to, so they need to export. So this tension is really, I argue, built into the law. Another reason for the tension is the multiplicity of actors that have been involved in developing the norms in this field, especially since the 1990s. So states are very much involved, including, of course, in the Arms Trade Treaty, but of course, civil society organizations have been as well. There's a movement, a broad movement called humanitarian disarmament that has been working on disarmament treaties for humanitarian purposes, and that has been involved. And so you see the tensions and the reflections of the interest of each actors. So since October 2023, there is a change, I would like to argue. So I won't go into all of these examples. I'm going to focus on two things, but my tentative argument is that some of this tension has been attenuated, and that the human rights constraints on exporting states have been made more resolute, okay, through specification and application and concretization of these previously vague and ambiguous norms. So I will give one example, first of all, in relation to Article 7 of the ATT. So the case which you've probably heard of, the Dutch case of Oxfam and two other NGOs versus the state of the Netherlands, which obtained, and the case is still being appealed, but obtained an order from an administrative court in The Hague, an order to the Dutch government to halt the transfer of F-35 parts to Israel. And so what's interesting here is there's a very broad interpretation of Article 7 of the ATT by the Dutch court. First of all, even though Article 7 obliges, from the language of the text itself, it obliges states to conduct a risk assessment prior to authorization, and there's a specific paragraph that says after authorization, states are encouraged to do this. The court in this case held clearly and explicitly that the risk assessment obligation also applies after the licenses have been approved. So it's a broadening of state obligations. And the interpretation of the very ambiguous term overriding risk is also, it's been clarified and as imposing broader duties on states. The court lumps the term overriding risk under the ATT with the standard in the EU common position, which also applies to the Netherlands, and interprets this as clear risk. Okay, and so it's just if there's a clear risk, the state determines that there's a clear risk that the arms or parts transferred to another state there's a serious risk they will be used in serious violations of IHL or IHRL, among other dangers. The transfer should not be executed, and importantly, the court here explains that this risk assessment can be based on past behavior, and this assessment of past behavior does not require demonstrating that the importing state violated IHL, whether in the current circumstances or in the past. Thank you. I'll say that at the same time, in the the April 2024 order of the ICJ in Nicaragua versus Germany, the court relied, in addition to the facts of the case, which obviously were very important there, but it also relied on Germany's export licensing regime, including the mere fact that Germany is a member of the Arms Trade Treaty, to deny precautionary measures. And here, this is an echo of this common practice of mere membership, okay, or the mere existence of a export licensing regime that takes into account human rights and IHL considerations as a legitimating factor for the state's export practices. So you see, so there's this battle being fought. Something similar could be said about the interpretation of Article 1 common to the Geneva Convention also in Nicaragua versus Germany. So first of all, Germany itself agreed that Article 1 applies to arms transfers. It has an external dimension that's relevant here. The question, of course, is what will be the standard that is applied in the context of that article? What exactly does it impose on states? So we don't know yet. The court only reminded at the end of the order, only reminded states of their obligations under Article 1. But I would note that in Judge Cleveland's declaration, she, like the Dutch court in relation to Article 7 of the ATT, seemed to conflate, or at least draw a connection between Article 1 common to the Geneva Conventions and the EU common position clear risk standard. So it seems that clear risk is emerging as a standard in different norms. And this is a clarification, but also a standard that's not so high or stringent. And more generally, even norms that are very difficult to apply and that require, like complicity or Article 41 of the Articles on State Responsibility, require an actual violation of international law to be determined by on the part of the importing states. These are being used by academics and UN experts to argue for a halting of transfers to Israel. So I'm really done in 30 seconds. I just want to give two possible explanations for these developments. So first of all, we're at a stage here, we're 10 years after the entry into force of the Arms Trade Treaty. And what we're seeing here is the maturation of a decade of civil society activism around the Arms Trade Treaty. The Arms Trade Treaty perhaps has been poorly enforced, but it's provided a platform for NGOs and like-minded states to meet every August at the Conference of State Parties and develop norms, submit interpretations, the ICRC to publish interpretations of Article 1, GC and its application to the arms trade. A lot to be said there. And finally, the particular characteristics of this conflict, the extreme violence diffused by social media, which we discussed yesterday, its successful framing, whether we agree with it or not. It's been framed in public discourse as a North-South colonial conflict that has enabled it to become a critical juncture in the development of these norms. A moment where the norms are being shaken up, and they could go definitely in a direction of more constraints on the states. And I hope I haven't gone over time. Thank you very much for listening, and I'm done.
Thank you very much. So our next speaker is William Wooster, who's a senior lecturer in public international law at the Hague University of Applied Sciences and an adjunct professor of law at the University of Missouri, Kansas City. He has researched and taught public international law, the law of international organization, and international migration and refugee law for more than 15 years after having worked as a lawyer in the United States and at the International Criminal Tribunal for former Yugoslavia. He's currently finalizing his PhD at the University of Amsterdam on the topic of diplomatic assurances in expulsion cases. He will speak on the topic of assurances on the use of exported arms. And we can see him now online. Good morning to you.
Perfect. Good morning. Thank you. Well, thank you so much for the invitation to speak and for the wonderful introduction, and also for accommodating the online presentation. It's of course my huge regret that I cannot be there with you. I'm deeply indebted to Natalie for her presentation already because she's spoken so much about the Arms Trade Treaty and some of these other frameworks that are relevant to what I'm going to talk about. So that will enable me to actually skip some of my slides here and move more promptly through the rest of the presentation and keep the time. So the focus of my paper is on how states should deal with assurances, statements, pledges, declarations that states make regarding the use of exported arms and their sort of promises that they're not going to use them for violating IHL. So the way I'll proceed through my paper is the first, I will very briefly mention the obligation to ensure respect, but I think I can pass through that rather quickly in light of Natalie's presentation. I will mention the international practice of assurances generally, because that's what this slots into. And then where I want to spend the bulk of my time is trying to glean guidance on assessing these export assurances and where we can find any information on how to deal with them. And then I want to conclude, if I have time, I want to conclude with the case study of the recent United States National Security Memo number 20 and its application or its analysis of assurances. So as I said, I'll go ahead and skip an extensive discussion about the Geneva Conventions and the positive obligation and the negative obligations that's involved. I think Natalie has already covered that. But we all accept that at least at a minimum, there's a negative obligation not to encourage or aid or assist, and that involves arms exports. So in reaction to this, and of course to the ongoing situation in Gaza, the Biden administration issued National Security Memorandum number 20 back in February, and where it said that if it has doubts or if it has concerns, it might ask states to issue credible and reliable written assurances about the use of the weapons that will be exported, and specifically that whether they would be violating international humanitarian law or other international law, and they just leave that other category open. So on the 14th of March, Israel issued assurances. These are quite opaque for now. Barak Ravidin from Axios reported that it was Minister Gallant who was the one who issued the assurances. I haven't seen that confirmed anywhere else, but that is, I'm going to presume that is indeed the case. So following the assurances, the U.S. State Department did its own internal assessment of those. It also did an assessment of assurances from several other states to which the U.S. was exporting arms, and put together a report and sent it to Congress on the 10th of May, stating essentially that they were satisfied with the assurances. For now, it's a little bit unclear just how widespread the use of assurances really is, because, as I said, it's rather opaque and tends to be through diplomatic channels and not really subject to much public scrutiny. As I said, the National Security Memorandum report covered multiple states, so we know at least that there were several states issuing assurances. And in that report, in the NSM 20 report, the U.S. State Department noted that the assurances that they had requested from Israel were actually a second round of assurances. They were already previous assurances on file, and that because of additional concerns, they asked for this supplement. So the question now is, how do we deal with these with assurances as sort of diplomatic communications within the context of all of these legal regimes and these sort of unclear standards that Natalie was talking about? All of this with the concern of trying to ensure the respect for international humanitarian law, the legal obligation to ensure respect for them. So diplomatic assurances have a long tradition, of course, in international law, going back many hundreds of years. States communicate back and forth to each other all the time. The sort of loose definition that I use, that I came up with, which is one just of my own development, is any kind of communication between states where they try to give the other state more confidence of some particular outcome occurring. They will just to say, you may have doubts, but we assure you that the following is going to happen. And they go by a whole variety of different names. Sometimes we call them diplomatic assurances, and that's a very sort of specific usage, although diplomatic channels are used, it's not always exclusively so. Other times they're referred to as guarantees or commitments or something else. And what they really collect is this real heterogeneous package or collection of all these different communications. They're not really a sort of known instrument. It's more of a description of the contents of other known instruments. So sometimes the assurances are requested, sometimes they are unrequested and just sent unsolicited. Some assurances are simply a unilateral statement, just like a letter or something along these lines. Other assurances take the form of an exchange of notes or memorandum of understanding. The UK has been has used assurances in the expulsion context, mostly in the context of MOUs and exchange of notes. A few of these assurances have even been considered to be legally binding. They haven't necessarily used the word treaty, but they certainly have treated them as such. In the recent Julian Assange case, for example, the US submitted assurances to the UK and asserted in court that they were legally bound under international law to comply with them. Some assurances are given orally. I'm not going to deal with those because it seems in this case that all these assurances have been given in writing. But throughout all of this, courts have been trying to figure out what to do with these diplomatic communications within the sort of legal sphere. The topics for assurances really span the gamut of different issues under international law. We've seen assurances on the use of nuclear weapons or security assurances, which may be familiar to many of you. A whole variety of different things, including, as I mentioned already, assurances in the expulsion context, which is something I want to come back to in a little bit. And specifically, we have already seen the use of assurances in the export context. A couple of examples that I can give already is that whenever the United States has exported nuclear material to other countries, they always request assurances on the use of that material. In addition, they have requested assurances for export of certain arms, specifically with the concern that those arms would then be re-exported to another country where the U.S. didn't want them to go to. So they may request assurances on that. Across all of this, the question is, can we draw parallels between all of these assurances? And State Department officials, including this excerpt from when Mike Pompeo was going before the Senate for his nomination to be director of the CIA, he asserted, and he's a pretty conservative person, as you can imagine, he asserted that yes, all assurances, this is the normal practice of diplomatic relations, and we assess them all on the basis of credibility and compliance issues. So bringing them all together into a larger pattern of practice. So I think we can compare different assurances. So what I want to do now is turn to looking at the various documents and the various legal obligations that we have to sort of figure out if there's any comments on assurances or any guidance on assurances. If we look at the Geneva Conventions, the conventions only mention in one article. This is the well, it's not common article because it's only common to 1 through 3. It's Article 11 in the Fourth Geneva Convention, but it's only mentioned once, the use of assurances, and that's not in the context of the obligation to ensure respect. It has to do with substitution of protective powers. And even there, the ICRC in its commentary said that didn't really give any standards on how those assurances were meant to be examined. So the Geneva Conventions themselves don't give us a whole lot to work with. The ICRC commentary observes that, of course, the negative obligation touches on arms transfers, and that the assessment of whether an arms transfer would violate that obligation has to be based on facts or knowledge of past patterns. It doesn't inform us where states are meant to get that information. But further on in the commentary, notes that states can undertake certain measures to ensure compliance with this obligation. And that can be through diplomatic channels. So diplomatic dialogue and protests and all the rest of this. So that would seem to suggest that assurances would be acceptable within this context. And that's about all that the Geneva Conventions really give us. If I switch then to the Arms Trade Treaty, and I won't repeat from what Natalie was talking about, but assurances do seem to be slightly dealt with slightly differently under the two articles of prohibited export. As Natalie was talking about, we have these different obligations within the Arms Trade Treaty. So for things like genocide or certainty of genocide, crimes against humanity, war crimes, we have a much stronger prohibition. And under Article 7, where we're talking about IHL human rights violations, it's a little bit more flexible, although the standard is lower in that in terms of certainty. I'm going to start with Article 7 because that's a little bit clearer in some ways. So under the Article 7 risk of violation of IHL, the question is, can a state ask for assurances? Well, the assessment under Article 7 in the ATT says that it's based on information provided by the importing state. So that seems to suggest that information can be communicated, perhaps even through assurances. In order to help us understand the ATT a bit more, there are a couple of soft law documents. One of them was produced by the ATT Secretariat, which collected all of this practice by all the states parties. The other one was prepared by the UNODA, UN Office of Disarmament Affairs, and they call it a toolkit. And what it is it's a training module where they give their advice based on their understanding of these obligations, how to implement them. Within the UN ODA toolkit, it, of course, reaffirms this obligation, notes that it's a due diligence standard, and then says that the state could discharge that with a formal commitment to apply the rules of international humanitarian law. And then that formal commitment, which sounds to me a lot like assurances, within that formal commitment would then be measured in light of a larger context of use and other measures that a state has put into place. In addition, if there's a risk under Article 7, the state can also mitigate that risk by adopting certain measures. Now, the ATT seems to contemplate that those measures are confidence-building measures of programs and that type of thing, but the ATT Voluntary Guide, which is this other soft law document I mentioned, contemplates, and this is based again on state practice under the ATT, contemplates that states can give and receive formal commitments to international instruments, so on and so forth. So again, this seems to contemplate assurances, and we can see within the text the kinds of commitments that they're contemplating. So commitments to international law, commitments to respecting IHL, et cetera, et cetera. Within the UN ODA, we have a very similar statement, also embracing this concept of using declarations of intended use, having undertakings or assurances or guarantees. And here, of course, they explicitly use the word assurances. So reaffirming that states can essentially make a promise to other states that they will not misuse the arms. But then they have to be assessed within the context of the state's practice, within the context of the state's overall compliance with international law and prior mitigation. Article 6 is different from Article 7 in that it does not seem to permit assurances at all. There is no provision for mitigation if there is this strong of a risk. And if we compare Article 6 to Article 7 in terms of the kinds of information that a state can use, Article 7 says that the information on risk can be acquired from the importing state, whereas Article 6 does not. Article 6 does not contemplate this, and both the ATT Voluntary Guide and the UN ODA Toolkit have both interpreted it in line with that. So they give this long list of all these different sources of information from think tanks and other things, but they seem to deliberately exclude the state that wishes to import the arms. So it would seem to me, if I can summarize the Arms Trade Treaty, then depending on what the risk is, for the risks, for the certainty risks of genocide and crimes against humanity. War crimes assurances are not appropriate to be used. But for the other issue of the possibility of IHL or human rights, it should be possible for states to issue assurances. That alone is not going to be problematic. Under
William,
the
William,
EU common,
5 more minutes.
perfect, thank you. Thanks
Okay.
for the warning. Under the EU common position, we have a somewhat similar approach because the common position is meant to largely absorb the ATT as well as provide for other bases. And it lists 8 different criteria that have to be complied with or at least considered for any arms exports. The EU has produced a user guide which has tried to explain how to comply with the EU common position in more detail, similar to the other guides I mentioned. And there again, they very explicitly say that states can give undertakings to each other on what the use is going to be like and to give formal commitments to each other. And I think the word formal is quite important here. Again, read within the larger context of the state's practices. So those are the instruments that are directly on point. I told you I would mention the expulsion context, and the reason why I mentioned expulsion context is that here we have quite a lot of jurisprudence on how to make predictions. We have situations where an individual could be expelled to a situation of torture or persecution or some other grave mistreatment, and states give assurances that will not happen. And courts have been grappling with this for quite a long time. The leading case is still Offman versus the UK that was at the European Court. That case has been cited by multiple jurisdictions, including ones that are not party to the European Convention. It's highly persuasive. And it lays down a whole variety of different considerations for assessing assurances. Obviously, in the expulsion context, but most of these are generally abstractable within the larger practice of diplomatic assurances and making predictions about them. And they say things like, have the assurances been disclosed, made public? Are they specific? Are they vague? Are they binding on the state? Can we expect authorities to comply with them? And then they also place that within a context. So what is the state's adherence to international treaties? What is the relation of bilateral relationships with the state, et cetera, et cetera. So, and I apologize for this slide because you probably can't even read it from where you are. But what I've attempted to do in this final slide here is just synthesize all of these little pieces of information. So we've seen all of these things saying we can have formal commitments here, you can have assurances here, you can have statements and declarations about this or that within this or that context. So I've brought all of that together for a whole list of considerations that seem to be drawing on these sources and that would then be applicable in the situation of arms exports. Now, I'm sure I have probably only a couple minutes left, so I will only briefly mention and come back to the National Security Memorandum. As I said, the U.S. State Department issued a report and sent that to Congress, and it provided its own list of criteria, which was pretty wanting. Essentially, the criteria that they laid down is they said the assurances have to be in writing and they have to be credible, and that involves who was the person who gave the assurances and are they essentially believable. They mentioned that there may be other criteria that they would assess, but they didn't mention what they were or how they were assessed in the report. Having mentioned that, the report then continued to ask 4 main questions for each of the various states, including Israel, that had given them assurances. And they basically ignored much of the methodological structure that they'd already laid down. So that's already quite problematic. So if I compare the approach that the NSM 20 memo took, they seem to miss quite a lot of things. The assurances are not publicly available. It's unclear whether they were binding, under what legal system. We don't know what the contents were. The report didn't report on them or even mention them. So we don't know the nature of the commitments. We don't know whether to address certain weapons. We don't know what kind of investigation mechanisms were in place. So it seems to me that there are a couple of failings, and I'll conclude in just a minute here. Not only did the U.S. State Department probably fail to apply its own criteria that it laid down, but it also seems to be not in compliance with the general practice of how we assess assurances in international law. And as a result, they essentially just looked at the past practice of what these different states have been doing, including Israel, and did not explain how simply examining past practice has any strong predictive value about the future, and thus whether or not there was a clear risk. So I'll conclude by saying it seems to me that the State Department has not concluded its due diligence effort. And as a result of that, and of course we know from reporting that State Department, internally State Department employees have protested and complained and said the report was altered and people have resigned and et cetera, et cetera. But what that means as a result is that if the US has not complied with its due diligence obligation, that it may have now failed to ensure respect for the Geneva Conventions and may potentially be liable, may incur state responsibility for that violation. Thank you very much, and I hope I didn't go too far over time.
No, you were exactly on time. Thank you very much for this excellent presentation. And our last speaker is Dr. Renato Wolf, who's an honorary research fellow at the Law and the Future of War Research Group at the University of Queensland, which means he's joining us from Australia. So I'm grateful for the time, I think, right? You're in the middle of the night, right? So, oh,
Not quite.
okay, right. He served as a legal advisor to the Swiss Armed Forces for nearly 10 years and was deployed to Kosovo and Bosnia-Herzegovina and to the United Nations headquarters. He holds a Bachelor of War and a Master of Law from the University of Bern, Switzerland, as well as a Master of Arts in War in the Modern World from the King's College London. He recently completed his PhD on the legal review of autonomous weapon systems at the University of Queensland in Australia. And Dr. Wolf will speak on the use of artificial intelligence decision support systems in the Gaza conflict through the lens of distinction and precaution under international humanitarian law. Please, 20 minutes.
Thank you. Thanks for the kind introduction, and thanks for having me. It's a pleasure to be part of the conference. And I will attempt to share my slides with you. Please let me know if that works. Can you see my slides and not the presenter mode? All right. So what I'm going to talk about today is probably a bit more like narrow than the title indicated. It's about a system called Lavender in the context of precautionary measures under IHL. For those of you who might not be familiar with Lavender or what precautions are under IHL, I'm going to quickly introduce both the system and the precautionary measures under IHL. Before I'm going to have a look at how precautionary measures could be applied in the context of a system like Lavender. What I want to today, sorry, it's almost night here, so I'll say tonight. What I'm not going to do today is to give you a definite answer of what I think, whether the use of Lavender in the Gaza conflict was lawful or not. That would not only go beyond what I have time today, but also I simply do not have the necessary information to do so. So to start with, what is Lavender? What is the system Lavender? So essentially, it's or what I should say before I'm going more into detail about what Lavender is. I'm basing my information largely on an article that was published by a magazine called Plus 972, which reported quite in detail on how this Lavender system was used in the Gaza conflict. I'm not in the position to judge whether these information are accurate and true. Israel has denied that quite a few of or quite a bit of the information that's in that article is accurate. But for the sake of example, for the sake of argument and for the purpose of this presentation and for the paper, I will just assume that this is accurate. Again, not implying that this is necessarily the case. So what is Lavender? The Lavender system is basically a piece of software that is used to identify Hamas operatives using some sort of artificial intelligence. And the way that it's done, it's in the first instance, a set of data is given to the Lavender software, and that set of data basically contains information, digital information about known Hamas operatives. So, for instance, the kind of phone connections they have, their social media they're using, basically a digital footprint of these Hamas operatives. Lavender then analyzes that and sort of identifies how, from a digital perspective, a Hamas operative looks like. Then the Lavender system is giving a second set of data that contains the sort of same information, digital information about the population of Gaza. And again, Lavender would sort of create the digital footprint of each resident of Gaza, and then assign a rating to each or most residents of Gaza, expressing similarity with the digital footprint of Hamas operatives. So, the rating appears to be between 1 and 0. The higher the rating, the more similar someone is to the more similar someone's digital footprint is to that of a Hamas operative. And when it reaches a certain threshold, that rating, it is assumed that someone is indeed a Hamas operative. Where exactly that threshold is, we don't know, but there appears to be a given a threshold that needs to be reached for a person to be considered as a Hamas operative. So then what Lavender then does, when someone reaches a certain threshold, it would propose that person to a human operator who would then, according to the magazine's article, verify whether that person is female or male. In case the person turns out to be female, it would be assumed that the system or something went wrong because there are no known female Hamas operatives. In case the person is male, that person will be put on the target list and then later attacked, which is sort of a different process. But essentially what the magazine claims is that once a person is on the target list, it has been decided that the person will be attacked. Again, I should just say in brackets, Israel has denied that this is accurate, and they claim that it would be sort of more follow a traditional approach where the final decision on whether the targets will be attacked is made by senior military officers in conjunction with legal officers and so on. Right, so that's Lavender. Very briefly, what are precautionary measures under IHL? There's basically 3 pillars. The first pillar is that each party has to do everything feasible to verify that the targets are military objectives in a legal sense. That will be the focus of today's presentation. The second pillar is that each party must take all feasible precautions in the choice of means and methods of warfare in order to minimize collateral damage. I'm not going to talk about that tonight, but it is discussed in the paper. And finally, the precautionary measures necessary to assess whether the attack would cause excessive collateral damage, which is not something I'm going to discuss later today or in the paper. So again, the focus of this presentation is the first pillar, the obligation to take all feasible precautions to verify. And the word feasible, I'll underline that. I will briefly come back to that at the end of the presentation. So what's the issue with precautionary measures and lavender? First of all, I should say that it is undisputed that states, when they're using systems like lavender, must apply precautionary measures just as with any other system. That would be undisputed. But the question is a bit more, well, how do you actually do that? And how can you assess whether it has been done by a state? Typically in the literature, the focus when it is discussed whether precautionary measures are taken or what is necessary, the focus is very much on the human operator. That human operator, in the case of lavender, makes this assessment about whether someone, the proposed target is male or female, but human operator obviously could have a much more extended role, and that's usually the focus of the discussion on precautionary measures in the context of these systems. But precautionary measures to verify don't start when the human operator comes into play. They start much earlier in the process, and that's what I will try to show in the next few minutes. How precautionary measures sort of can be or have to be applied throughout the process before the human operator even comes into play. Even though the human operator can be and is potentially an important plays an important role in the precautionary measures, but it's by far not the only one. So when you think of having an obligation to, for instance, distinguish at all times between combatants and civilians, one of the basic pillars of IHL, and how you apply that into practice, into the effect on the ground where it's decided whether a civilian or a combatant is hit, then you have basically 4 steps. The first thing you have to do is you have to legally qualify the people you're intending to attack. Are there lawful military objectives? I'm just giving you an example. You qualify enemy members of the armed forces as military objectives that can be attacked. That is the first step. You have to know whether what you want to attack is actually can be done lawfully. Then the second step, that is sort of like maybe a bit unfamiliar, but it's important in the context of lavender. And I will come back to that. The second step is the target description, where you have to decide by what features can the persons you qualified as military objectives be identified. And again, the simple example would be after you've decided that the enemy members of the enemy armed forces are military objectives, how do you identify? Well, they're wearing a uniform, the sort of country-specific uniform, which identifies them as members of the armed forces. So that would be your target description in that case. And then the third step, you would actually identify. You would be out in the field and say, okay, I see a person. That person fulfills the target description / it is wearing that uniform, and therefore I can consider that person as a target and attack. And then finally, you deliver the effect to the identified target. Like you direct the rifle towards that person, you pull the trigger, and the bullet may or may not hit that person. And I would argue that the first 3 steps are subject to the obligation to take precautionary measures to verify, and I will discuss them a little bit more in detail in the next 2 minutes. Whereas the last step is covered by different provisions, for instance, the obligation to minimize collateral damage. So I will not discuss the 4th step, but I have a little bit of a closer look at the first 3 steps. So the legal qualification of targets, again, we'll ask, are the persons we are trying to attack lawful military objectives? In the case of lavender, it is a question of Hamas operatives. Do they qualify as military objectives in a sense of in a legal sense? And I think it's important to underline here that based on all the information we have, lavender plays no role in that legal qualification. So as I say here on the slides, Lavender wouldn't say, colloquially speaking, I think these people here, these Hamas operatives, qualify as legal, as military objectives. Why don't you, consider them to attack them? What Lavender does is say, I identified people you considered as military objectives. So Lavender doesn't play a role here. What the legal qualification of targets is likely done in a very traditional way, again, with senior officers in the room, with intelligence officer providing information, and with legal officers providing legal advice. So I think it's important to underline Lavender doesn't play a role here. However, you still have the obligation to take all feasible precautionary measures to ensure that you correctly qualify the persons you were intending to attack. Then the second step, and that's where it's sort of interesting with Lavender, is again the target description, where you determine by what features can you identify your targets. And in the previous example, I said the combatants, right? That was relatively easy to take the uniform, but with the Hamas operatives and the use of Lavender, the way you identify them is by their digital footprint, and again by the similarity of that footprint to known Hamas operatives, expressed in that rating. So it's any person who has a rating above a certain threshold, again, we don't know where that is, and is male, can be considered as a Hamas operative. The problem is now, you have to decide whether these two groups of people, the group of Hamas operatives and the groups that fulfill these conditions, this target description, having a rating of higher than the threshold and are male, are identical, or at least identical enough. And we know that in the case of Lavender, out of 10 people attacked, one is most likely a civilian and not actually a Hamas operative. So there is probably a divergence between these two groups in practice. So when we think of precautionary measures, what will be possible? Well, you could increase the rating that is necessary, the threshold. You could say, for instance, if that 1 in 10 civilian is the result of a rating of 90, you could say, well, I increase the necessary rating for a target to be considered for a person to be considered as a target, as a Hamas operative, to 99. By that, I obviously reduce the number of civilians falsely identified as Hamas operatives, which is obviously what is desirable from a humanitarian law perspective. But on the other hand, what it does, yes?
5 more minutes?
Yeah, thank you. So what is the downside of that is that it also means that you're identifying less actual Hamas operatives. So in sort of more technical language, you reduce the number of false positives, civilians identified as targets, but you also decrease the number of, increase the number of false negatives, Hamas operatives identified as civilians and not as actual Hamas operatives. So I will skip the next precautionary measure because I'm a bit short on time. So the last step would be the target identification. That's where sort of Lavender itself is functioning. Again, there you could have possible precautions, giving the operators more time to access more information. You could train the operators how to sort of assess whether the system has made an error, make them aware of machine bias. So this idea that people could basically assume that everything the machine proposes will be correct. So there's a few things you can do with this human in the loop. This human operator does the verifying of the targets. But I think what I was really trying to show is that precautions are much broader. They don't just apply to the human in the loop. And the final point, I think I still have 1 or 2 minutes, I wanted to make is regarding the precautions, possible precautions versus feasible precautions. So all the precautions I was mentioning, I refer to them as possible precautions because I assume that can be done, like it's possible to do it. But from a legal perspective, it's important to distinguish between possible precautions and feasible precautions, which are legally required. So what this feasibility proviso essentially tells us is that states are allowed to take into account military consideration when they're deciding whether they have to implement a certain precautionary measure. And this military consideration could, for instance, be that they decrease their military effectivity because they have fewer targets they can generate with the system, or they need more resources to generate the same number of targets. That doesn't mean none of the precautions I mentioned are feasible, but it's just we can't automatically assume that every precaution that is possible is also legally required. So that's probably all I'm trying to say tonight. Happy to answer any questions if we have time for that. And thanks again for giving me the opportunity to talk to you today.
Thank you very much.
Hi, thanks so much for the presentations. I found them really interesting. I think my questions are more directed to Natalie and William. So Natalie, I was just wondering if you've taken into account, there was a case actually on Friday that the Dutch court ruled on this issue. And basically what they found was that these types of rules cannot be applied blanketly. They have to only be applied to specific export licenses. So I think it's just, probably should take a look at that. Also, the case you've been talking about in terms of the appellate decision actually was argued before the High Court in the Netherlands back in September. So the decision hasn't come out yet. I don't think they're going to come out with a different legal standard that the appellate court did, but I think we have to keep that in mind, that it's still right now being decided by a higher court. And then I wanted to ask both of you sort of about, well, actually also William, just in today in the news, looks like there's a lawsuit that's been filed in the United States on the NSM letter. So you should look at that. But I wanted to ask you sort of what you think about the political considerations, because while I do think that's the legal standard, the devil is really in the interpretation. And it really seems, because I've also been tracking these cases very closely, that it's really dependent on the government in charge and how they're interpreting the standard, because we've even seen it now. There was one way of interpreting these rules, but then when we had a change of government, it actually switched the interpretation. So I think, again, we're still really in the realm of politics rather than a normative standard. And also just in terms of assurances, in the Netherlands, actually the United States Senate was sending letters to the Dutch government that they should not be applying a policy limiting the F-35 due to, the Dutch would actually be jeopardizing their status in that program. So I think these are, if we take a little bit broader view of assurances also, not just simply the government, but other branches of government. Thanks.
Thank you. Please.
Thank you so much. My name is Johannes Ayalo. I'm a postdoc here at Hebrew University. So my questions are quite brief to Natalie and Renato. The first one is, you mentioned about civil society mobilization. So recently I read the report by UN Special Rapporteur Ben Saul about the export of arms to Israel, and he mentioned, I quote, 99% of weapons from US and Germany are sent to Israel. So if we stop that overnight, the war will end. So how do you see the influence of UN special rapporteurs in addition to civil societies? To Renato, you mentioned about on the issues of false positive and negatives. So in those cases, whenever such things happen, how could human decision maker verify further to make precaution and possible targets. Thank you so much.
Thank you. Could you pass it to Odin?
Did you have a question?
You have a question? Sir?
So thank you. A question to Renato and a question for Natalie and William. For Natalie and William, I think that there are two things that we're seeing in the space surrounding Common Article 1, where we see, I think, a fairly clear trend at the ICJ, from the ICRC of pushing one interpretation. On the other hand, and this was really clear if you were at the recent quadrennial of the ICRC, some states have really made that interpretation a non-starter, and in the U.S., the U.K., Canada, Israel, and some other states are saying that they just completely disagree with this interpretation. And the question is, how is this going to get resolved? Because it seems like we're just started talking past each other on this point. For Renato, a question and a comment. So I was wondering, during your research and presentation now, have you thought of the distinguishing line between precautions in attack and reasonable certainty, or whatever evidentiary standard you're looking for the purposes of distinction? Because I think those two norms obviously are related and affect each other, but there are really important ramifications of saying, well, this is a violation of precautions, or is this a violation of distinction? And you could think of international criminal law, for example, just one ramification. So that would be interesting to hear your thoughts on. And I'll also comment that the factual basis that you've decided to present on is in stark. There's a stark difference from that and what the IDF has publicly put out there, and there's a fairly detailed publication on this issue, which usually is shrouded in secrecy, and obviously there are limitations on sharing information on intelligence capabilities. But one of the main things that caught my attention, discrepancy between the two accounts, is the categorization of lavender as something that's used for targeting full stop, or the fact that lavender is just a database used for a number of things, detention operations, intelligence operations. And in that sense, I think there's a lot of assumptions going on to how this database is used, and that framing really makes a big difference in possible conclusions that we'll jump to. So that's just a comment, which if you could react to, that'd be great. Thanks.
I'll begin. Yes. Thank you. So I'll just go in order. So Anne, thank you for the comments. So just very briefly on the other Dutch ruling. Yes, I mean it's this whole regime of export control is done case by case, and it's an accurate. It's not a surprising ruling to rule that you can't make decisions in bulk, but that doesn't change, that doesn't affect, the other interpretations that were made about being argued before the High Court in September. Yes, I said this is ongoing. It's still subject to appeal. On the political aspect, I mean, of course, I'm doing this from a social legal perspective. In my explanations, both for the tension that's present in the field and for the changes we see now, those explanations are partly and perhaps largely political, right? So I talked about mobilization of civil society, about the framing of the conflict as North-South, and within that, you can say, so Israel is an unpopular actor now, and it's a sort of an easy case on which to develop these norms, and of course we see the difference most strikingly in the position of the UK government when the government changed. Okay, that's all there, and those are in the causes. That doesn't, that's how international law is made. There are of course political forces shaping it in part. That's one of the forces, and it's not any different here. yet the product is norms and a change in the normative interpretation. So they're still being formed now, but we can see this output in decisions of domestic courts, the beginning of it at the ICJ. I'll answer directly Johannes's question. What is the role? How do I see the role of UN special rapporteurs here? So they are also contributing. You know, even if they're not a formal source, I cited them when I said UN experts. So that's what I'm referring to. A number of statements in which they do the work of connecting certain norms like Article 16 and 41, complicity, and applying that to obligations of arms exporting states, GC1, Common Article 1. So they're like academics, academic blogs. They're an important contribution. It's all these little micro contributions that perhaps don't have the force of authority, but that are contributing to the development of the law. Odine's question, how is this going to get resolved? I really don't know, and I think what you said, what you posed here is really an example of this war has provided sort of an opportunity there's a battle here over the meaning of the obligations of arms exporting states. So I gave examples of more resolute human rights protections, but perhaps in the end, due to the structural causes of the tensions. I mean, at the end of the day, the economic structure and geopolitical structure of the global arms trade is not changing because of this war, and perhaps that will be stronger than anything else. So we're at a juncture here, and I don't know where it's going to go. Thank you.
William?
Thank you. Let me I agree with what Natalie said and also build on that. The case is definitely pending in the Netherlands. The Dutch Procureur-Generaal, which is kind of like an attorney general, has already issued an opinion on this that basically agrees with the Court of Appeals. And it would be highly unusual for the Supreme Court to disagree with that opinion. So I think that the writing is on the wall. I didn't hear about the lawsuit in the US, but in a sense, so thank you so much for drawing my attention to that. I was working on my slides last night, not following the news. Politics, for sure, 100%. Of course, politics are involved. I agree with, and I completely on that one. So the question, though, is within this highly political environment, can we find any normativity? And my argument is we can. We know that there is a due diligence obligation, and we know that that's a normative obligation that comes out of GC1 and or the Common Article 1. Then the question is, given that we have a due diligence obligation, and this runs across all of international law, whether we're talking about climate change or anything else, where we have all these due diligence obligations, we're trying to figure out what's the normativity that's involved in there. And of course, there's a lot of room to say that there is some normative standards in there, but of course they're subject to particular interpretations and pressure. So we always have this interesting bedfellows between politics and law. You mentioned also the different branches of government having different perspectives on this. Also agree 100% on that. The court in the Netherlands saying the export was not valid, and then Mark Rutte, who was prime minister at the time, his government appealed it to the Supreme Court because they didn't want to jeopardize the F-35. But one interesting distinction, though, about the Dutch case, and this we'll have to see what happens in this American case, but in the Dutch case is that the export regime is subject to challenge by NGOs, Oxfam in this case, amongst others. And that's not necessarily true in other legal systems. Certainly in the US, and that's why I'm very curious about this NSM. It's difficult to say we're gonna challenge an export on this. What's the legal basis? What's your standing for that? Whereas in the Netherlands, there is a specifically prescribed them. That's why the courts can insert themselves in there, and they can bring their normative approach to that. And then just quickly, lastly, on the interpretation of Common Article 1. Controversy, yes. I'm not sure it's as controversial as some state actors like it to be, or wish that it would be. I think a lot of the controversy is the question of whether there's a positive obligation compared to whether there's a negative obligation. I mean, I would suggest that there's pretty widespread agreement that there's at least a negative obligation. Whether there's a positive, yeah, okay, we can have a discussion about that. But we know that there is an obligation to ensure respect, and that should at least accrue a negative obligation. I will mention just quickly that the Arms Trade Treaty Secretariat, when it put together its voluntary guide, they surveyed all the states parties to the Arms Trade Treaty. We're talking about 116 states that include all the members of the European Union, Australia, Brazil, Canada, China, Japan, South Africa, UK, etc. And they found widespread agreement that not only was there a negative obligation, but also a positive obligation. So yes, there may be some pushback by, a few states, the U.S., Israel, maybe Russia, and some others. But I'm not sure that it's really as contentious as your question assumed it to be. But thank you for that.
Thank you. Renato?
Thank you. The first question, I'm not sure I've understood correctly because the audio was a bit patchy, but I understood it as how can human operators assess whether a target is lawful? I think, it can be many things, but I would assume that it would require that the human operator has access to some more data than the software had, and I think it's just bringing into play sort of human intuition and sort of uniquely human features to conduct this verification. So yeah, I think that's probably a bit the vague answer, but I think it really depends on the circumstance, and I think it's important to underline that this is one way you can do it, but like to have a human operator sort of doing a more in-depth assessment, but it's not necessary under international humanitarian law to have a person in the loop, I would argue, but I'm sure that's up for debate. But yeah, I think that's unfortunately quite a vague response. Regarding the question of precautions in distinction, I did have a little bit of a look into that in the paper. And I agree, like just because you apply all feasible precautions doesn't mean you're fine. If you still, your level of distinction is still so poor, you can have taken all the precaution measures you want, but if it's still, so poor, it's still an indiscriminate attack, or it's still a violation of the principle of distinction. I will probably just add in brackets that I don't think from the numbers we have from the magazine's article, that these would indicate that the principle of distinction, Article 48 or its equivalent in the customary international law, would be violated. I don't think that, but again, that's up for debate. Then the remark about, or the comment about, sort of my assumption that working with the magazine articles, yes, I'm aware of Israel's response, and I hope I made that clear during the presentation. I certainly flagged that very clearly in the paper. This is just an assumption. I'm not in a position to assess whether the magazine's article is good, and I'm not going to question Israel's response to that. The main reason why I chose to base my presentation and the paper on the article is because it is quite frankly more interesting legally, and I think it describes a method that many imagine is how artificial intelligence decision support systems will be used in the future, if not now, certainly in the future. And I just thought it's an interesting opportunity to take this information from the article, I assume they're correct, and then discuss how precautionary measures would apply to that. But again, I'm not in the position to say, yeah, the article is right and Israel is wrong. If I based my paper on Israel's claim, it just wouldn't be, sort of, it's not very different to how things are done now and without AIDSS. It's sort of much more a traditional approach that is far less interesting to discuss issues such as precautions. So I hope that answered that question, or that they
Thank you very much.
responded
So
adequately to the content.
thank you. So we're going into overtime. So this means the questions are 30 seconds tops. No comments, just questions, please, and the answers relative. Okay.
Thank you. So I'll deal with the arms trade issues only, and thank Renato for his presentation. So I thought the analogy by William is an interesting analogy with the extradition deportation area where there is use of diplomatic assurances and there is controversy over them. I think one area where so I have two questions in that regard. One is one of the areas that we've seen development in the field of extradition, but mostly deportation, is in the field of fact-finding. And if you look at the decisions in the Netherlands and the comparable decisions in Germany, where the cases have been thrown out, the main difference is the methodology of fact-finding. And whether do you see states developing in this area the kind of fact-finding infrastructure that was developed, for instance, in the asylum cases, where there are some countries that have agencies that compile, collect on an ongoing basis information about the situations in home countries where asylum seekers come from. And there, of course, are also many issues in that regard. And for William, just on the issue of Article 6, so I see the point that the practice has been to focus the assurances discussion on Article 7 as a matter of practice. But conceptually, when you think of the analogy to deportation extradition, there the assurances also play a part in negating knowledge about the risk. And I'm wondering conceptually, if you have an assurance that this is not going to be used in a certain region or in a certain weapon system, can you still say that the state has knowledge that it would be used in a way that would violate international law? So that point conceptually, I was not sure that I got.
Thank you. So we have online a question from Alexander, right? So can you bring him up?
So it's actually a brief comment to William. I'm sorry, but I'll be brief.
So just briefly, please. Yes.
A brief addition on the interaction of assurances with domestic law. So it seems to me that assurances really also measure under states' domestic legal obligations as a way to fulfill duties to protect. For example, in Germany, we're also having domestic litigation on arms exports to Israel. As a general matter, the courts seem to accept the notion that there is a duty to protect the right to life of foreigners abroad as a matter of the German constitution. But courts then say, well, at any rate, that constitutional law duty can be fulfilled, among other things, by asking for assurances, as Germany has done vis-à-vis Israel for the export of arms. So just to say, well, while courts here are noting that assurances matter, and they refer to the long-standing international law tradition of issuing these, they really don't seem to have any criteria at all for assessing these. There's really no scrutiny. It's just an escape route and a tool of sort of blanket deference, if you will. So just to say that your research would also seem to be very relevant in those domestic contexts. So thanks for that.
Thank you very much. Eitan, you know? So Yali? Okay. So just very brief answers, please, from the... No, don't take me too seriously. You can answer. No.
There were no questions to me, but I just want to say in 30 seconds about fact-finding methodologies that one of the methods that could be emerging is actually AI. I'll just mention that legal counsel to NSO, when asked about how they claim to make a human rights assessment before entering into transactions, and he said the first step is they have software and that
GPT.
not ChatGPT, but they said they developed software for the risk assessment. So I would not be surprised if that figured also in states tools for this.
Okay. William?
Great, thank you. So as to the fact finding or development of fact finding, definitely, because if we look at the NSM memo to Congress, and that was one of my biggest critiques, which is that the methodology is just sorely lacking, even following the Department of State's own criteria that they laid down, their fact finding was quite poor. Maybe they just don't release it and make it all public, but even from what it was made public, I think was quite wanting. The same thing with the Netherlands. They were really caught out by the F-35 case because they'd already issued this export license. So I take your point. It may very well be that we need to have an emergence of a fact-finding infrastructure. About Article 6, yes, really important point that I had to gloss over in my presentation. So for the Article 6, where you have the strong likelihood of genocide, etc., it seems that the Arms Trade Treaty certainly does not allow mitigation. But the question is your exact point. Can you submit assurances at the point of developing that knowledge of the strong likelihood? So if we look at the Arms Trade Treaty Voluntary Guide, it does seem to blur those categories. And it seems to entertain the idea that states can have communications and that somehow that could have some implications at the knowledge state. The difficulty is that if we go back to the Arms Trade Treaty and we look at the distinction between Articles 6 and 7, Article 7 specifically says in the ATT itself that states can consider information provided by the importing state. Whereas if we switch to Article 6, it does not have that language. And so by implication, one would suggest that you're not allowed to form that. But conceptually, I'm completely on board with you. That's a difficult distinction to make. And I'm not sure I have anything more intelligent to say on that particular point. And then just about the last one about the interaction with domestic law, yes, completely. So one of the categories coming from, say, the Othman case is not only are these assurances, binding under international law and blah, 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 but some of the other criteria have to do with how are they implemented in domestic law, and are they likely to be, does the person who issued them have control over the people who could blah, 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 blah. So there's a number of domestic law implications, but I will push back a little bit on saying that there's no scrutiny. Part of that is the emergence of this new jurisprudence. So in terms of expulsion, that's partly why, if you look at the Committee Against Torture or the European Court of Human Rights, how many cases are expulsion cases? That's like half their caseload, and most of them involve assurances. So it's a very rapidly evolving field. And now through often we see the emergence of criteria coming out of the jurisprudence that places like Germany are going to have to absorb. Thank you.
Thank you. Renato? Do you have any?
I don't think I had any more questions, so thank you.
Okay.
Thanks very, very much.
So thank you everybody for a very interesting session. And